The title of the presentation is The Law of Political Exclusion in Libya, a case study of a failed transitional justice process. As a consequence of the Arab Spring, a number of Arab countries have political transition from authoritarian regimes to more representative political regimes, which in turn has put to the forefront the issue of transitional justice and how to deal with the personnel inherited from the old regime, or what is commonly called as the issue of personnel reform. Transitional justice is a term that has mainly emerged during the 1980s, which refers to a strategy or a way of thinking about justice after, as a result of past injustices. But the concept actually comes back to the end of the Second World War and the Nuremberg and Tokyo trials. So it is also in this respect worth noting that these two trials were mainly based on ideas about principled justice after atrocity and practical concerns such as reluctance to apply collective responsibility, which might have risked hampering post-war rebuilding, and especially in the case of Europe. Prosecutions and criminal justice processes are considered to be the central elements of most transitional justice processes, and have in certain cases been completed or complemented by other processes such as truth-telling and illustration mechanisms. In Latin America during the 1980s, the transitional justice process relied on prosecutions and criminal justice processes, as well as on truth commissions in order to deal with past injustices, just as the previous speaker has just explained. Whereas in Eastern Europe, after the fall of the communist regimes, illustration or vetting policies were the main mechanism used in implementing transitional justice processes. In this respect, personnel reforms are measures of transitional justice that are motivated mainly by past abuses of power, how to deal with past abuses of power. In addition to the Latin American and the Eastern European experience, it is also worth mentioning the African experience in that respect, because it is a very original experience that was based on a combination of criminal prosecutions, truth-telling commissions, reparation programs, and programs of institutional reform. In addition, and this is the originality of the African process, in addition to relying on local cultural values and practices, as it was the case for South Africa, Uganda, and Rwanda. Indeed, in the case of South Africa, for example, it was argued by Archbishop Desmond Tutu and Nelson Mandela that individual prosecutions would not produce the desired results and were incompatible to local conceptions of justice. And as such, a specifically local conception of justice based on what is called in African vocabulary Ubuntu, or a philosophy which is a philosophy grounded in notions of unity and forgiveness. And as a result, this concept of unity, or this philosophy of unity and forgiveness, according to them, should be part of the transitional justice process. The importance of the African experience with transitional processes lies in the fact that it reacted to, and here I quote, the possible imperialism of international justice by putting forward locally legitimate, culturally particular alternatives. Now, before dealing with the political isolation law in the case of Libya, I think and I thought that it would be interesting to give you a little background of the political map of Libya after the fall of the Gaddafi regime, in order to understand what were the mechanisms and the reasons that led to passing the law of the political exclusion law. The institution or the parliament that passed this law is known as the General National Congress, that was elected in July 2012. And it is also important to note that this parliament, when it was elected after the fall of the regime, but especially after the fall of the whole Libyan state, because actually the Libyan revolution or the Libyan uprising has led to the fall of the system that was put in place by Muammar al-Gaddafi for 40 years. That was a personal system that has systematically destroyed all political institutions in Libya, in the Libyan state, that has systematically destroyed any possibility for any alternative emerging from political elites in the society or from the civil society. So the electoral process that took place, or the political transitional process that took place after the fall of the regime of Muammar al-Gaddafi, took place with this background, which means that in a situation where there was everything to build, nation building and state building at the same time. So if we look at the outcome of this process, the result of this election, is that the fall of the Libyan regime, or the Gaddafi regime, has led to a reconfiguration of the Libyan political map in a radical way for the benefit of local forces and non-state players. These forces are represented by the local councils, the coalitions, the tribal coalitions, and the armed militias that have dominated the political life of Libya after the fall of the regime of al-Gaddafi. And all this, of course, all these forces emerged at the expense of the attempts to create new institutions like the National Transitional Council, for example, or even the General National Council later on. Indeed, if you look at the results of the elections for the General National Council, which is composed of 200 seats, we can see that it is divided into 120 seats for independents and 80 seats for the lists. In addition to a regional distribution of 100 seats to the west, 60 seats to the east, and 40 seats to the south. So it is grounded on this repartition of seats in the Libyan parliament that the elections took place in July 2012 and gave the following results. The first, main result is that local forces emerged, or the independents emerged as the main player in these elections. Most of the forces, or those who emerged in these elections, with the exception of the Islamists, had no ideological content. And the seats were divided into 39 seats for the National Forces Alliance, led by Mahmoud Jibril, the Party of Justice and Reconstruction, the Muslim Brotherhood representative, with 17 seats, the national small national lists with 6 seats, the Salafis with 4 seats, and local lists with 14 seats. Whereas the repartition or distribution of seats on individual basis gave 25 seats of independents affiliated to the National Forces Alliance, 17 seats affiliated to independents and affiliated to the Party of Justice and Reconstruction, and 23 seats for the Salafis and independents affiliated to small nationalists. in addition to 55 seats for non-affiliated independents, which gives a total of 120 seats. In this respect, it is worth mentioning that with the exception of the Islamist candidates, the majority of the independent candidates represent family or tribal interests. As this is very obvious from the details of the election results, where 2/3 of the independent candidates won their seats with less than 20% of the votes, and more than half with less than 10% of the votes. In this respect, if we take the case of Benghazi, 6 out of 9 of the independent candidates were elected with less than 2% of the casted votes. This situation is due to the fact that the Libyan electoral law did not put a limit on the number of independent candidates or lists for each electoral circumscription, and as a result, a very large number of independent candidates and lists competed on a very limited number of seats. Regarding the issue of the ideological labeling of the political forces present in post-Qaddafi Libya, there is a widespread belief that the liberal political trend represented by the National Forces Alliance and its leader Mahmoud Jibril was the big winner of these elections, and that the Islamists were the losers of these elections. However, when we look at the details of these elections and the results, the picture looks quite different, and for the following reason. The first is that the real winner of these elections are the independents and the local forces, who represent family and tribal interests. The second, in the case of the NFA, or what is known as the liberal forces, represented by Mahmoud Jibril, it is very difficult in the Libyan context, or even in the Arab context in general, to define them as liberal with the ideological content that liberalism has. The third reason is that the number of seats the Islamist forces managed to win in these elections, including the independents affiliated to them, is almost equal to the number of seats won by what is called the liberal forces. So we have around 60 seats for what represents the Islamist forces, including the independents, and around 64 seats for the National Forces Alliance. In addition to the 55 seats of non-affiliated independents that could vote on one side or the other of the spectrum. In addition to that, the cleavage between the political forces in post-Qaddafi Libya is not found, or is not to be found only between the big political forces or between the Islamist and non-Islamist forces, but also and especially in the opposition between the revolutionary and anti-revolutionary forces as a direct consequence of the Libyan revolution. Indeed, we can find on one side of the post-Qaddafi political spectrum the supporters of the Libyan revolution, represented by the Muslim Brotherhood, the Salafis, the exiled opponents of the Qaddafi regime, or some of them, and representatives of the cities and rebel strongholds in Misrata, Zawiya, and Jabal Nafusa, among others. And on the other side of the political spectrum, we have the individuals and tribes that collaborated with the Qaddafi regime, as this was the case with the Fazan region in the south, and Sirt, and the Bani Walid tribes. It is based on this political map that the political isolation law was passed by the GNC in May 2013, with the declared objective of excluding officials from the Qaddafi era for a period of 10 years from holding public office in the government, civil service, police, judiciary, and banking. It is worth mentioning in this respect that the isolation law was passed in very controversial circumstances, and especially under the pressure of militias, the revolutionary militias, that have directly targeted the members of the GNC, in addition to surrounding public buildings like the Ministry of Justice and Foreign Affairs. So, I mean, the legitimacy of this law itself is, to be discussed, knowing that actually military force was used in order to push the GNC in order to adopt and pass this law. According to this law, those who are presently holding public office will have to be reviewed by a body called the Integrity and Patriotism Commission, which will decide if the concerned officials can continue holding office or not. There is indeed an appeal process, but it has been rarely used by the concerned people. And when it has been used, it has proven to be not very efficient. So basically, the appeal process is empty, is not really very efficient. When talking about the political isolation law, it is also interesting to note that it is very similar to the de-Ba'athification law in Iraq, enacted by Paul Bremer, the head of the Coalition Provisional Authority in May 2003, with the same devastating effects on the political stability and the political transition processes of these two countries. The most direct consequence of the political isolation law is that it has excluded key figures in Libya that have played a key role since the beginning of the Libyan uprising in February 2011, followed by the transitional process that started in October 2011. Indeed, according to this law, the then president of the GNC, Mohammed Maghrayef, and then Prime Minister Ali Zaidan, and Mahmoud Jibril, the leader of the NFA, and the Prime Minister of the government that has led the political, diplomatic, and military efforts against the Gaddafi regime, all these personalities were automatically excluded from the new political map in Libya. And actually, Mohammed Maghrayef resigned immediately after passing this law, and he was the head of the GNC. As a consequence, it is not a surprise to see all these figures, or most of them, now siding with the Tobruk government and the dignity operation led by the retired General Khalifa Haftar against the GNC and their allies within the Libya Dawn coalition of revolutionary militias. There is no doubt that there is a legitimate need to protect the emerging new state from the return of the main representatives of the Gaddafi regime, and that it is in need of a transitional justice process, but without excluding large sections of the Libyan society and without jeopardizing a necessary national reconciliation, as this is happening now as a consequence of the political isolation law. The political isolation law, unfortunately, has not served the objective of a necessary national reconciliation and has greatly contributed to the actual armed conflict, without mentioning transforming Libya into a failed state. Indeed, a consequence of this law is that the new Libyan state is deprived of the emerging of the already scarce, talented political leaders, as well as qualified civil servants in the state apparatus. So we can clearly say, and without doubt, that the political isolation law is a divisive law that is already leading to, in addition to other consequences, to institutionalizing historical divisions in the Libyan society, and which is not at all helpful for a national reconciliation. There is no doubt that the political isolation law has led to increasing number of losers from the transitional process in the Libyan society. And as a consequence, it has led a number of forces that were part of the revolutionary front against Gaddafi to side now in the actual armed conflict with the Gaddafi loyalists, as this is the case of the NFA, of Mahmoud Jibril, the Zintan tribes, as well as the federalists in eastern Libya. As a consequence, the political isolation law belongs to the category of exclusive personnel systems that are defined as personnel systems which provide for the automatic exclusion of officials associated with the old regime from the state apparatus of the new regime. In this respect, it is good to have a look at some other experiences, and especially regarding the personnel reform process in transitional countries, as this was the case with some Eastern European experiences with what is known as the lustration laws. Lustration laws are defined as specific public employment laws that regulate the participation of people associated with the former regime in the new political system. And they represent a different, more inclusive approach to the personnel reform dilemma, as this was the case in Hungary and Poland, where the discredited personnel was given a second chance under particular conditions. In the case of the Hungarian inclusive personnel system, the condition for retaining public office was exposure, which means that the people that were associated with the old regime were given the option to either resign or to have their past roles and activities publicized. Through this system, the new government was able to retain the qualified personnel and establish transparency. The Polish reconciliatory personnel system was a step forward from the Hungarian inclusive model, as it also included a process through which the confession of the person who applied for a public position was scrutinized by the public and a special prosecutor, who verified the disclosed past activities and positions in the old regime. If the concerned personnel disclosed all relevant facts, he was given a second chance to hold public office. If he concealed any fact, he was dismissed and banned from holding a public office for 10 years. The difference is that in the Hungarian system, this process of scrutinizing what the official or the person is declaring does not take place. So we are not sure to what extent that person actually revealed all the details of his past activities or positions. The Polish reconciliatory personnel system resembles the South African truth and reconciliation process. While in Poland, the old regime personnel was given an opportunity to hold a public post in exchange of self-revelation, in South Africa, gross human rights violations were offered amnesty for making a full disclosure of all relevant facts. Both systems have offered an authentic personnel reform system within an essentially macro-political process that helps engage in complicated political transitions. And now, with the ongoing conflict in Libya and following the decision of the Constitutional Court regarding the parliament based in Tobruk, and that it has declared that it was an illegitimate parliament and that has to be dissolved, what is the way ahead? I think that in that respect, if there is any will from the GNC now in order to help Libya move forward, I think that the GNC should take a very quick initiative by freezing the political isolation law or by cancelling it, in order to open the door for a negotiated political settlement among all the different forces in Libya, and in order to contribute in putting in place a more inclusive policy of national reconciliation. In addition, a transitional justice process in Libya, I think, should look very positively and be inspired by the African model of transitional justice that has relied on a combination of international systems or concepts in addition to more locally concepts. In the case of Libya, the transitional justice approach should rely and should use the Islamic principle of tawbah, and by putting in place a mechanism that would allow for the implementation of the concept of al-diya, or the financial compensation in case of gross human rights violations, including the case of loss of life. But this, of course, has to be put within a very clear process and mechanism. However, it is feared that the zero-sum game mentality prevalent in Libya and in the region, in addition to the unfavorable regional context, that they will not be very helpful in achieving this objective, as it seems very clear that the counter-revolutionary forces in the region, represented by the UAE, Saudi Arabia, and Egypt, are more interested by a security military approach rather than in a transitional political approach. And on the other side, there is also the belief among the revolutionary military militias that only a military solution can solve the situation. In my opinion, this is a very destructive approach. I don't think that there will be any military solution to the conflict in Libya. And I think that an open political process that would allow for a national reconciliation to take place is the only way out for Libya, in order to avoid, of course, Libya jumping in a full and total civil war, in addition to the consequences that it will ultimately have on other countries of the region, like Tunisia, Algeria, Egypt, and maybe further. Before I conclude, I would like just to make some general observations regarding the main characteristics of Arab Spring transitional justice processes. When we compare with Latin American and Eastern European experiences of transitional justice processes, the Arab Spring transitional justice process, with the notable exception of Tunisia, drastically lacks the relative consensus within the society about the new political contract to be put in place in replacement to the previous imposed from above authoritarian social contract. In Latin America, as well as in Eastern Europe, there was at least a largely agreed agreement within the society to build a political system based, and here I quote, on what was called the Washington Consensus. This agreement does not exist now in the Arab world. And actually the whole debate is not only about just the transitional justice process, but about the configuration of the new regime that will have to emerge after the fall of these regimes. And thank you very much.